as I'm sure many of you know, the usual reason for planning appeals is appeals against refusal of planning permission or enforcement notices. The issue that often stumps people is what happens about costs, because generally speaking it's the belief that costs are not awarded in planning appeals normally, and indeed that's correct. Each party pays its own way. But if there has been unreasonable behaviour on either side, then there is scope for an application to be made to the planning inspector for a cost order against that person. In quite a lot of cases it tends to be the local authority, because they have perhaps not attended a hearing or a site visit, which is pretty unusual, but it does happen. It could affect the conduct of the proceedings. It could result from an inability to produce evidence in support of a detailed planning permission, and that happens quite often. Sometimes when it's an individual rather than the local authority, it arises because an appellant is pursuing an appeal upon grounds which are clearly no hopers in the first place. So the local authority might get costs then against that individual or firm. Also, if you withdraw one or more reasons without good reason for refusing planning permission, that can go to unreasonable conduct, and particularly so if an inquiry has had to be adjourned or unreasonably prolonged, causing wasted expense. So there are many reasons why cost orders are made. It's probably sensible to put an application in, if you're going to make it, for cost orders before the planning inquiry and appeal actually starts. It doesn't have to be then, but it's preferable to be then. So what happens is that the inspector will hear arguments separately from the inquiry or appeal on costs, and each side submits its reasons why there should be a cost order against it, or on the other side why there should be no cost order against it. And eventually the inspector will make a decision. It's always in writing and it's usually very thorough. But at the end of the decision comes an inspector's order that one party should pay the other party's costs. Or of course there may be an order that there's no order for costs, but I'm dealing with the case where an order is made for costs. Now, whilst that's an authoritative decision, it's not a court order, and this is where a lot of people come unstuck, because obviously if you pursue it to enforcement, you may have a chance of enforcing it on the basis that the other side recognise it's an order and ought to pay up, but a lot of them don't. So the answer is to convert that inspector's order into a High Court order. And whilst that's not essential to do, it's preferable to do it for a number of reasons. Obviously the most important one being that it can be executed in a normal way like any other High Court or County Court order, and it has the same standing as one of those once it's converted. It also has the advantage of carrying interest at an enormous rate of 8% per annum on the outstanding amount of the costs. So that's the tactics behind making orders, and that is really ought to be followed in every case if you want to achieve a satisfactory result. So how are the costs determined? Well, once the High Court order has been obtained, then it can slot into the usual provisions for assessment of costs in any litigation. And so what happens is that you apply to the court for an assessment of your bill of costs. Obviously you will have had to go to a firm such as ours to draw the bill and prepare the costs so that they are properly identifiable, and we would make sure that they are properly recoverable. Once the bill is drawn, you could try to settle it by agreement, but if not, you then, as I say, latch on to the normal procedure for assessment of costs by issuing proceedings for assessment of costs, and that automatically follows a predetermined path, in that once the bill is served, there's 21 days for the paying party, as it's called, to provide points of dispute to that bill, listing all the items that they object to, and then you have another 21 days to respond, to explain why the points of dispute are erroneous or misguided. When all that procedure is completed, you apply to the the Senior Court Costs Office for a hearing, and it then goes before a cost judge, whose task is simply to decide whether the costs are reasonable or not. At the end of that hearing, the judge will decide what the overall sum payable should be. And there you are with planning appeal costs. The latter part of it is very little different from any other litigation cost, but to get there you have to follow the procedure I outlined, like converting the inspector's order into a High Court order. That is very important, not to be missed.